In a medical malpractice case in New York, when your case goes all the way to trial, if a jury determines that your doctor was careless and that his carelessness was a cause of your injury, are they obligated to compensate you money as a result of all the harms and losses and damages that you incurred? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, they are. If, after the entire length of trial, now the jury is deciding on their verdict, they have to answer a series of questions. The first question has to do with who, if anyone, is responsible for your injuries. If they find that the doctor whom you have sued is legally responsible for your injuries, then they have to determine whether his carelessness was a cause of your injuries. It doesn't have to be the cause, it only has to be a cause. If the jury determines that yes, your doctor was careless, and yes, his carelessness was a cause of your injury, now they get to the issue of damages. How much money are you going to receive for each element of damages that you've claimed in this case? Pain and suffering from the past, from the time of the event up until the time of trial. How much suffering can you be expected to suffer into the foreseeable future, from the time of trial for the next 20, 30, 40 years? Now, that's all important. How much are your medical expenses? How much have you lost in earnings? All of those things the jury will have to consider. But you may be asking yourself, will they be required to give you money to compensate you if they have found that the doctor was careless and that his carelessness was a cause of your injury? The answer is yes, the jury will now have to compensate you and give you money for your damages. Now, the question of how much is a different issue. That's a different issue for a different topic on a different day. But the reality is, once they have reached all those questions and answered yes, now they are obligated to consider the amount of money that you are to receive. Now let me ask you a question. If the jury gives you a specific amount of money that is much lower than you have requested, at the end of the trial, can you, the injured patient, can you go ahead and try and get that amount increased and say, hey, wait a second, what was the jury thinking? My damages are so significant, they're so extensive, how could the jury only have given me this amount of money? The answer is, yes, you can. There are procedures available to ask the trial judge to increase that amount of money for a particular part of your damages. That is a possibility. Now, do you think the defense lawyer is going to roll over and say, okay, judge, whatever they ask for, we'll agree to? No, that's not how it works. That's not how any of it works. The defense is going to fight you tooth and nail on every single issue that you're trying to increase. And now, if the trial judge turns around and says, you know what, I'm going to leave the jury verdict as it is. You have a problem with it? Take it up on appeal. So now you do have the opportunity, you do have the option to try and appeal to a higher court, to the appellate division, and say, hey, listen, ladies and gentlemen of the appellate division, 5 members of the panel, we don't think that for this element of damages, let's say for pain and suffering into the future, where this patient now is going to endure all these terrible surgeries, all because the doctor was careless, we don't think that $10,000 is a sufficient amount of money to compensate her for all the injuries and the pain and the suffering she's going to endure for the next 30 years of her life. And then the defense will have an opportunity to put in their argument. And then the appellate panel, 5 judges, will then have to consider whether or not the trial judge made an error of law when telling the jury what to consider, whether or not there was an error in coming to their conclusion. And if they find that there was an error, the appellate court has the ability to increase that amount of money. They also have the option to say, you know what, we're going to take that part of your damages that the jury gave you, that $10,000, we're going to throw that out. And now you're going to have a trial on damages alone. And you'll bring in whatever medical experts you need in order to justify that this patient, that you suffered a significant injury and are now entitled to a certain amount of money. So hopefully you'll get a better result as a result of the jury giving you a small amount of money for one particular part of your damages. So why do I share this great information with you? I share it with you just to give you an insight and a look at what goes on in these medical malpractice cases here in New York. You know, I understand and I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need answers, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.